Getting told you have to stay put until the bailiff comes and not protecting property are probably two of the biggest things that councils do and get away with because simply people don't push back on them. Now, I saw a really interesting case come up last week from the local government social care ombudsman, the LGO, as I kind of tend to call them. And if you haven't already, it's worth going on the LGO's website, lgo.org.uk, and just subscribing to those newsletters because there is so much information in there, it's unbelievable. And this one came up involving Portsmouth City Council. On the face of it, it seemed to be just about protection of property, but it actually includes gatekeeping and also being told to wait until the bailiff comes. So I thought it might just be interesting to really unpick it, and I don't know how to do this without reading out large blocks of it. So I've tried to just kind of keep the bits which are most relevant. Obviously, if you'd rather just read it yourself, the link is in the description. But I'll try and pull out the bits which are going to be most useful for us. And effectively, this guy, he's in private rented accommodation. He's got lots of debts, and he has PTSD among other conditions. So ultimately, he is in priority need through vulnerability. That was the ultimate finding. And he approaches the council, and interestingly, his landlord was a relative who had been harassing him. Now, bear in mind, this might mean that the definition of domestic abuse kicks in. So domestic abuse includes people who are part of your extended family. So that's just an interesting consideration to look into as we go through. And basically, there was some initial issues with contact. So when this guy initially contacted the council, I think he gave them the wrong number or something like that, and basically it took them a little while to get back to him. So there's some things in there's some delays in this which were not the council's fault. It was because of misinformation or mistakes or whatever. But basically the complaint was that the council had not told him that they had a duty to protect his property, and they required him to stay put in his accommodation until the bailiff came. So after an eviction notice had been given. So bearing in mind, in the Section 21 process, you get the Section 21, that expires, you are likely to be legally homeless the day after that expires. You then go to hear the possession proceedings, you're then given an eviction notice, and basically the further down that process you get, the less and less likely it is that you're not homeless. And that's something that this LGO decision picks up. So as I say, I'm going to have to read blocks of it. I apologise that my voice is particularly boring, but anyway, so the summary of the complaint is that Mr X complained the council failed to provide appropriate advice and assistance and support with storage costs when he was made homeless. The council was at fault as it delayed providing interim accommodation and failed to advise Mr X about storage options. This caused him distress and uncertainty and storage costs. The council has agreed to apologise to Mr X, refund his storage costs and pay him £300 to acknowledge the distress and uncertainty caused by the delay in providing interim accommodation. It has also agreed to issue reminders to staff regarding discussing storage costs with applicants and on providing interim accommodation when it has reason to believe an eligible applicant is homeless and in priority need. Now, a little bit of a pernickety bit here I just want to pick up on. In this summary, the LGO has actually given the wrong threshold of interim accommodation. It does use the right one further down. There's a really important difference because what it's saying in this opening paragraph is that the interim accommodation duty is owed when the council has reasons to believe an applicant is eligible, homeless and in priority need, not maybe. And that's really important because it's such a low threshold. And actually by getting this stuff mixed up, and I see it getting mixed up quite a lot, essentially what they're doing is they're misapplying the threshold and inserting an artificially high threshold on here that only has to be reasons to believe that you might be homeless, might be eligible, might be in priority need in order for that interim duty to accommodate to kick in. So there's some kind of overall bits which I'm just going to skip through. But if we go down to paragraph 14, the LGO says that the Code of Guidance states that it is highly unlikely to be reasonable for the applicant to continue to occupy beyond the date on which the court has ordered them to leave the property and give possession to the landlord. So, as I say, that is kind of quite a way down the eviction process. At that point, it's highly unlikely for that person to be, not legally homeless at that point. And bear in mind, the interim accommodation duty kicks in if there is reason to believe that you might be homeless, might be eligible, might be in priority needs. This should have happened at that point. It then gives a little summary in paragraph 18 of the protection of property, where the council owes or has owed certain housing duties from an applicant, which is essentially things like relief duty, prevention duty, interim accommodation duty, main duty in theory. It must protect the applicant's personal property. If there is a risk it may be lost or damaged. A council may make a reasonable charge for storage and reserve the right to dispose of the property if it loses contact with the applicant. So I'm actually going to go across the Code of Guidance here because I don't think that summary in that paragraph does the actual guidance justice. Because the duty kicks in where A, there is a danger of loss of or damage to the applicant's personal property, B, because the applicant is unable to protect or deal with it, and C, no other suitable arrangements have been or are being made. So, as I say, there needs to be the fact that the applicant genuinely cannot actually afford to deal with it themselves. That's when this duty would kick in. As I say, I'm not sure that the LGO summary there does it full justice, but again, the Code of Guidance is obviously easily available. We then go down to paragraph 21, which gives a kind of, again, it's like a potted history of what happened. So it says, in January 2023, Mr. X contacted the council and provided his telephone number, as in the right telephone number this time because the previous one was wrong. He said his landlord had obtained a possession order on the grounds of rent arrears which would expire in early March. Mr. X explained he had long-term medical condition, mental health problems and PTSD. He owed money for his utility bills and had credit card debts. He was expecting an eviction notice and had lack of funds to move out. The council wrote to Mr. X to advise that it had accepted the relief duty and sent Mr. X its assessment and a personalised housing plan. It sent Mr. X information about mental health support service. So what it doesn't do here is basically look into priority need in any detail or make a decision about it. So then in 23 it says, Mr. X provided the council with details of the bailiff's warrant for his eviction in early April. Records show that the council officer tried to call Mr. X that day and the following day, but his phone was off. The officer arranged interim accommodation for Mr. X from his eviction date. Again, you can read the full decision, but I'll skip to the most salient points. And so basically what happened at this point was they offered interim accommodation and they found that he was in fact in priority need, but they said he was intentionally homeless. He then challenged that decision, which is brilliant, so he did a really good job here. And effectively, on review, they realised that the accommodation was not actually affordable for him, so they overturned the intentional decision, and therefore he was in priority need, he was not intentionally homeless, and they therefore owed him the main housing duty, which is that longer term duty to provide settled accommodation that's suitable and so on. So paragraph 26, in late May 2023, the council concluded its review that he's not intentionally homeless. It said there was evidence of an inappropriate behaviours by his relative and that Mr. X's mental health had deteriorated. It said it noted Mr. X had not previously indicated he needed to leave due to domestic abuse. However, it had not been possible to inquire with the landlord about the dynamics, and it was evidence there was blurred lines due to the nature of his relationship. It overturned the decision and Mr. X's interim accommodation became temporary accommodation, so that's that main duty kicking in. During this time, he basically spent out something like £2,000 in terms of storage costs. So at this point, the council had not mentioned the fact they had a duty to protect his belongings if he couldn't afford it, and effectively, I'm guessing here he was taking out loans or something in order to pay these costs. So it wasn't actually until July that the council said, okay, we've actually got a duty to protect your property. And so Mr. X basically asked them to backdate the payment. So all the money he'd paid out until this point, which is about £2,000, he asked the council to backdate it, and they basically said no for no good reason. Actually, they should have done it. And so once Mr. X had complained about this later on that year, the council essentially seemed to be quite inefficient with dealing with the requests, because he was asking for them for backdated money. They kept asking him for bank statements. He was saying, well, I've given them already. He ended up then refusing altogether because the council hadn't explained to them that they needed to see updated statements in order to process the payment and so on. So again, it was kind of, there was some fault in there from the council. And then the LGO's findings from paragraph 38, which I'm going to read a lot of, state that when Mr. X approached the council in January 2023, the council accepted it owed him the relief duty as it had reasons to believe he was homeless and eligible for assistance. Now, actually, again, this is the LGO getting it slightly wrong. The relief duty does not kick in until the council is satisfied that the person is homeless and eligible. So notice there's two thresholds. One is reason to believe that the person might be homeless, might be eligible, might be in priority and so on. But the relief duty does not kick in until the council is satisfied that they are in fact homeless and eligible. So again, it might seem pernickety, but this is the law. You know, the LGO should be getting this right, in my opinion. The letter makes no reference to whether the council had reason to believe he was in priority need, so again that was a failing. The council's failure to record its consideration of this and to notify Mr. X of his decision as to whether he had reason to believe he was in priority need was fault. The threshold for having reason to believe someone is in priority need is low. Again, it should be might be in priority need is low. Mr. X had explained his mental health issues and long-term health condition and the difficulties in relationship with his landlord, who was also a relative. So that says to me that they probably should have been a little bit more proactive looking into that relationship with the landlord, as in whether there was domestic abuse, but certainly there seems to have been ample evidence that he was in priority need through his health conditions. Paragraph 39. The Code of Guidance sets out that it's highly unlikely to be reasonable for an applicant to continue to occupy a property beyond the date of possession order. Mr. X told the council in late January his landlord had a possession order, so in one sense there is definitely reason to believe he might be homeless at that point. The council failed to assess or document how it considered this and whether it was appropriate for Mr. X to remain in his current accommodation on a temporary basis. Now, as far as I can tell, the only reason the council could advise you to stay put is if they have another offer of accommodation, or if you found another offer of accommodation that's going to be kind of available within a kind of month or two, and therefore it makes more sense to remain in the property and then move straight into your next home rather than go through temporary accommodation. That seems to be the only situation where that might arise. The council did provide Mr X with interim accommodation once he received an eviction notice, and it considered he was in priority need when it decided he was intentionally homeless. On balance, I therefore consider, had the council properly considered all Mr X's circumstances in late January, including his rent arrears and concerns about his landlord's behaviour, the council would have reached the view it had reason to believe Mr X was in priority need and his current accommodation as not suitable to occupy, and so would have provided interim accommodation at that time. The council's fault meant Mr X had to remain in accommodation it was no longer suitable for him to continue to occupy longer than he should have. This caused him distress and uncertainty. Then we get to paragraph 41, the storage costs. There is no evidence the council discussed storage costs with Mr X or offered him any support to protect his belongings when he moved into interim accommodation. This was not in line with the code of guidance or how the council says it operates. Now, it didn't actually have any policies, but it just said, oh yeah, we would do that naturally. Obviously they don't, and was fault. Mr X was evicted due to rent arrears and provided the council with evidence of debts with utility companies and with credit cards. Had the council properly assessed Mr X's circumstances at that time, I'm satisfied it would have offered him support with the storage of his belongings. The council would have been entitled to charge for the costs, but at an affordable rate. So councils can charge you for that service, but essentially they'll enter in some kind of repayment plan which is affordable, so a fairly low repayments over a long period of time in order to actually pay that money back. Mr X arranged his own storage at the expense of other debts and then requested assistance from the council. When Mr X approached the council for support, it said it would not help with payments he had already made. This was fault. The council said Mr X had already protected his belongings, but it had discretion to make decisions based on circumstance of the case. It failed to properly consider Mr X's circumstances and whether it was reasonable to backdate any storage costs. And then finally, paragraph 44 and 45, the agreed action. So within 1 month of the final decision, the council has agreed to apologise to Mr X and pay him £300 to acknowledge the distress, uncertainty and frustration caused by its failure to offer interim accommodation in January 2023. We've published guidance on remedies which sets out our expectations for how organisations should apologise effectively to remedy injustice. So that's kind of talking about the fact that councils should not just kind of like, you know, sort of shrug off stuff. They should actually take responsibility for it, and kind of their language should reflect that. So he gets the £300 for the distress and so on. He also gets a refund of £2,144, which was the storage cost he paid out. And in addition, paragraph 45, within 1 month of the final decision, the council has agreed to remind relevant staff that A, the duty to provide interim accommodation arises as soon as it has reasons to believe an applicant might be eligible and in priority need, and also might be homeless, by the way, and B, to discuss the issue of storage of belongings with applicants when they are moving into interim accommodation. So I'll finish this video with a little bit of the law on this, because section 184 of the Housing Act 1996 is probably one of two sections you actually need to remember. So you need to remember section 184 and section 188. And section 188 is the interim accommodation duty. But section 184 is that initial duty to people who've asked the council for help with housing and given the council reasons to believe that they might be homeless or they might be threatened with homelessness, because in that section it basically lists out what the council need to make inquiries into. And essentially it kind of says anything within Part 7 of the Housing Act 1996, which includes this storage cost. So basically the law says that if you make a homeless application, the council should specifically look into whether you need any help to protect property. And as we see in this case, there doesn't appear to have been that conversation at all. But that should have happened, and that's kind of the reason why it should happen, is that there's actually a duty to make those inquiries. And I'd argue as well there's a duty to provide that advice and assistance anyway. That should be just default stuff. But because so many councils get away with not doing it, a lot of people have never heard of this protection of property duty, but it is there, and this is the kind of situation where it can be very helpful. So again, if you haven't already subscribed to the LJO's website, do so, because there's this sort of stuff happens every week. This is a really interesting case, and for me, I find the way they lay out this information just makes it very easy to follow, and you learn a lot of stuff without actually kind of realising you've learned it, because it tells you the process it should go through. So I just want to say thank you to everyone who subscribed to the channel. Just really appreciate all the good comments that are coming back. They're the good questions. If you've got questions about the law, stick it in a comment, anonymise it, don't put it in the first person, just say it's about someone else or a what if question. I would then take it to the next live stream, unless there's an easy way of me answering it, where every Thursday night, 7:30 PM, myself and my colleague Shannon, and then Will and Karis from Virgo Solicitors basically discuss a number of questions, as many as we can do in the hour, just to kind of give a bit more nuance to it, because it's very difficult to always articulate the intricacies of this just in writing, so it's much easier to discuss it. You don't need to watch it live, you can just basically tune in afterwards. It's recorded on the channel, just find it in the live section of the channel. And I do my best to index the questions so you can kind of follow when I'm asking which question. And if you're a professional who finds stuff interesting, do check out the training we do online. We have an open session basically once a month, so again, very reasonably priced, starting at £30. If you're coming from a professional organisation, it's £60. It's a day's training. It might sound deadly, but actually the feedback we get is brilliant. People just really finish the day buzzing, and we just cover the kind of the foundational principles of housing law and how everything else fits in, because there's now a couple of hundred videos on this channel just looking at different issues. So we're not obviously going to cover all that stuff in one day, but it gives you that kind of founding framework of understanding how priority need and intentional homelessness fit into it, how to make a homeless application itself, all that kind of stuff that you can then build up from it from the videos on the channel as well. So a lot of people are finding it very useful, and I'm seeing some really interesting examples where people have come on the training and they're now setting up their own advice services basically in their locality, which just makes me so happy, because yeah, sometimes it is a little bit kind of depressing, this sector, isn't it? But I think just kind of seeing people get hold of it and starting to help people out is exactly what this channel is all about. So again, if you want to find out more about that, just check out the Eventbrite link in the description, and you also get to meet some really nice people as well.